I mean, our system only works if the rules are followed. And fortunately, we had a judge here that was going to force them, or tried to force them, but they still didn't follow.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today, as usual, is our famous co-host, Lester Tate. Hey, Lester, how you doing today?
I'm doing great. I'm glad to know I'm famous and not infamous, though. I think more people think of me as being infamous. So,
one or the other. Depends on who you ask. Doing all right today?
Doing great, and looking forward to talking to our guest today.
Same here. We're excited to have Lance Cooper on as our guest today. Today, we're going to be talking about products liability law, and specifically about a defect in the Chevy Cobalt car that was uncovered by our guest, who's a trial lawyer, not a police detective. And that is none other than Lance Cooper, trial lawyer extraordinaire, who is with us today. Let me tell you a little bit more about Lance. Lance Cooper is the founding partner of the Cooper firm and represents clients in catastrophic injury and wrongful death cases. He specializes in products liability cases involving automobile design and manufacturing defects. Lance has been lead counsel for plaintiffs in a large number of jury trials, including trials against General Motors, Ford, Toyota, Kia, Chrysler, Honda, as well as other motor vehicle manufacturers and large corporations. His 2011 wrongful death case against General Motors, Melton versus GM, exposed the cover-up of faulty ignition switches, resulting in millions of recalled vehicles. And we're going to talk a little bit more about that. Lance received his law degree from Emory University in 1989, my alma mater also, where he was a G. Joseph Tauro Scholar and Editor of the Harvard Journal of Law and Public Policy. He received his bachelor's degree in political science and economics from the University of California at Berkeley in 1985. Lance served as the 2002-2003 president of the Georgia Trial Lawyers Association and is a past president of the Cobb County Trial Lawyers Association. He is a member of the American Association of Justice and was honored to receive the Stephen J. Sharp Public Service Award in 2014. Lance was also a 2014 nominee for the Public Justice Trial Lawyer of the Year Award. In addition to his law practice, Lance is actively engaged in numerous community and charitable activities. He and his wife, Sonia, are the proud parents of 5 children, Rachel, Rebecca, Michelle, Asa, and Aaron. Lance, welcome to the show.
Thank you, Robin. And just to add to the resume, it's now the proud grandparents to 4 grandchildren.
4 grandchildren. Oh, my goodness, Lance.
Hopefully many more.
You cannot be that old.
Yeah.
Because I think we're about the same age.
Lance, our friend Roy Barnes once said that grandkids are the gift God kills you for not killing your kids when they're teenagers. So I see you've come into your full reward here.
That's right.
And I'm interested, what do your grandchildren call you? What's your name?
Papa Lance.
Okay, Papa Lance. Sounds good. I like that. Well, Lance, you obviously have had great success in the plaintiff's world of litigation. And I'll tell our listeners, I've been honored to work with you on a couple of car manufacturer defect cases, and certainly learned a lot from working with you and enjoyed those couple of cases. But our listeners are mainly lay people. So I wanted you to just take a few minutes and explain what we mean by products liability, and specifically the type you specialize in, crashworthiness or products liability involving car manufacturers.
Sure. Well, products liability, essentially, when you boil it down, it's just proving that a product is defective and that defect caused someone's harm. And there are really two main areas in that. There's the manufacturing defects and the design defects. So for example, if somebody makes a product wrong and it fails, then they're responsible for that manufacturing defect. That's what happened in part in the Melton case, the Cobalt case we can talk about, but it also was a design defect in ways. And the design defect is simply, hey, the vehicles or the product, they're all made the same way and they have an inherent design defect that makes them unsafe. So those are the two main areas of product liability law that I deal with are the design and manufacturing defects.
And is there any particular Georgia law that applies to those cases that doesn't apply to, say, just a plain old car wreck case? Sure.
Well, in particular for the design defect cases, the law is unique because when you have to prove a product is defective by design, you have to show that there should have been a better design. In other words, was there an alternative feasible design that was available that the company chose not to use? And what takes place there is judges and ultimately juries evaluate the evidence, and that is, it's a risk-benefit analysis, and that is, did the company, if there was an alternative design, did the company risk more than the benefit? So for example, if they decided, we don't want to spend the extra $20 to make this product safer, the jury ultimately has to decide, well, did you act reasonably? Should you have spent the extra $20 to make the product safer? In other words, was the risk that this product was on the road greater than the benefit that the public gets from that product? And it's a little complicated, but at the end of the day, jurors are basically asked, was the risk worth the benefit? And if it was, then it's not defective. If it wasn't, if they should have incorporated the design. So for example, not every vehicle can be a Mercedes-Benz SUV with all the modern safety technology, because in certain cars wouldn't be affordable. However, there are certain basic safety features that should be on all vehicles. And so that's what the jury ultimately is asked to consider is, did the company, and it comes down to basically a question of reasonableness, did the company act reasonable under the circumstances?
And let me guess, a car manufacturer never admits it did something wrong.
No, and most of the time they'll say obviously their designs are reasonably safe, and that what our experts are suggesting is unreasonable. That's the pretty standard fight that goes on in the courtroom.
So, Lance, one of the other things that often seems to pop up in products liability cases, warnings. And or failure to warn, of a particular hazard. And I know, for example, like on bucket trucks, which is something I've sort of dealt with, if they don't have the right labels to tell you not to step here or not to utilize it in a certain way. Does that ever come into play with your products liability cases against consumer automobiles, where maybe a manufacturer actually knows about a defect and then doesn't warn in the form of doing a recall or something like that?
Yeah, and what's interesting is in the warnings cases, as you know, Lester, you really don't have to prove the product's defective. And the best example is this. Y'all probably remember back in the early 90s when the airbags in minivans were killing children that were riding in the front seat. Those airbags weren't defective, but the parents of those children didn't know what the car companies knew. And the car companies knew in their testing, these airbags are too powerful for children to be in the front seat. And there were a number of fatalities where the federal government ultimately got involved. And what happened? A warning. And that is, they didn't change the airbag, but they compelled the manufacturers to put out these graphic warnings: do not allow your children to ride in front seats. And before that happened, parents didn't know. And once that happened, as we all know now we're close to 30 years later, you're not supposed to put your child, still now because of airbags, you're not supposed to put your child, if they're of a certain height and weight, in the front seat. That's the classic warnings case, because you can't fix the airbag. It's going to deploy in a way that is going to protect a lot of people, but it's going to hurt children. And so they were ultimately warned too late, unfortunately for many families, ultimately warned, keep your children in the back seat.
And I'm going to guess that rule of keep your kids in the back seat if they're in a car seat came about because a trial lawyer brought a lawsuit against a car manufacturer and was successful in bringing it. I always think that, if your car is safe, thank a trial lawyer.
You're exactly right, Robin. In fact, I've spoken often about this. If we go back to the Pinto case back in the 70s, which is sort of the first notorious product liability case, the fuel tank cases, it was a trial lawyer, a trial firm that discovered that defect. And if you go forward to the fuel tank cases involving pickup trucks in the 80s, it was trial lawyers who discovered that problem. The problem with airbags we just talked about, up until most recently, the Takata airbag defects, those were uncovered by trial lawyers. And unfortunately, the government, although they have a regulatory and oversight of the manufacturers, oftentimes, and not oftentimes, almost always, they aren't able to uncover defects. It takes trial lawyers using the civil justice system, and frankly, courageous families who are willing to stand up to these automotive manufacturers and other manufacturers to make sure that justice gets done. And what's important about the civil justice system is it not only allows for an individual family to go into court and hold a company accountable, as we just talked about, it brings about societal change. And there are a lot of safety devices in vehicles because of what families and trial lawyers on behalf of families have done over the years.
You mentioned courageous families. We're going to talk about the Meltons in just a minute, but my guess is you've had many courageous families who you've represented who have lost a loved one. And I'm wondering about when that family first comes into your office, probably with the death of a loved one, and then they tell you their story. How do you know you might have a products liability case, or specifically a defect in the automobile? How do you even know that?
Oh, I've been doing this for almost 30 years now. And although I'm not an engineer and I'm not a medical doctor and I'm not a police officer, investigator, you tend to initially, when you have the initial conversation, understand this is more than just what the police officer said in the wreck report. There may be more here to the story. And so oftentimes we'll have initial meetings with potential clients and we'll have to tell them, no, we just don't believe we can help them, unfortunately. And as you know, that those are hard discussions to have. But the point I always make in those discussions is the last thing you want to do is be, a lawyer telling you he thinks he can help and you get your hopes up. And then at the end of the day, they can't help because it makes your suffering even worse. And so we have those conversations, but, oftentimes we also basically tell people, those families, we're not sure if we can help, but there's enough here to investigate. And then what we ordinarily do is investigate on behalf of the client. And in this case, in all product liability cases, the first piece of evidence you look at is the product. And then you look at the circumstances surrounding the use of the product. And then, get engineers and experts involved. And then you'll have the next meeting where you either tell the clients, yes, we think we can help, or no, unfortunately, our investigation shows that for whatever reason, it's just not a case we can pursue.
And that involves, I guess, obtaining the car, correct? And holding on to the car to have it inspected?
Yes. So every time we get an inquiry, the first question we ask, and oftentimes, as you know, we get inquiries from fellow lawyers who don't have expertise in a particular area. And we want to make sure that the vehicle or whatever product or investigation is secured. And we take immediate steps, not only to, for the insurance company to say, well, yes, it's secured, but actually to get it to our evidence facility. So we really know it's secured. That's an investment that we make in every case that we investigate. And it's an investment that ultimately, if we don't pursue the case, we tell the clients, you don't owe us anything back. We just want to make sure we preserve whatever we can, spend the time and the money to do that in order to determine whether or not they have a case.
But that can be a very expensive process. I know you're talking about sometimes buying a wrecked car, but then, as you noted, you're not an engineer or a doctor. You have to have people with some expertise maybe to look at that. And so what's your conversion rate on that? How many cases do you look at versus how many you end up taking in the end?
Well, yeah, again, and it's basically three separate categories. The first category is in the meeting, in the initial review, if we don't believe there's a case there, then we don't take the next step of securing the evidence and hiring the experts. But if we feel like there is, ordinarily, I would say at least, so I can't really give you a percentage, but it's less than half of the cases that come in the door from a product standpoint where potential clients come to us that we take the next step for whatever reason. Because these cases are very difficult, time consuming, and obviously expensive. But once we make the decision to retain experts and secure the vehicle, I would say in excess of 50% of those cases we take, just because, as I was telling Robin, we've got the experience internally here to do that initial review and just believe something went wrong here. So for example, if there's a car wreck and 3 people walk away and one person who's belted is catastrophically injured or killed, those kinds of things that they raise your antenna, like, wait, something must have gone wrong with a safety feature, or it may have gone wrong, and that's what causes us to take that next step. And more often than not, when we take that next step, we find that there is a defect or a problem with the vehicle that contributed to the harm.
We're going to talk about the Melton case with the ignition switch defect. But before we get into that, Lance, can you tell us examples of the types of defects you've handled in car cases and cases before?
Yeah, so we can, I guess, start from the bottom to the top. My first product liability case I ever handled back in 1992 was a tire failure case where a tread separated on a vehicle, and this is another, I guess, to give a pat on the back to trial lawyers. This was when those old SUVs like the Bronco 2s and the Suzuki Samurais were defectively unstable. And it was trial lawyers who ultimately got these companies to make more stable vehicles and ultimately safer SUVs. But that's an aside. So the tire cases, we've handled axle failure cases, airbag cases, seatbelt cases. We have seat back cases now, which are probably some of the most common defects we see, where there's a rear impact and the front seats fail and cause an injury, catastrophic injuries or deaths oftentimes. And then all the way up to roof crush cases, where a roof is inadequately designed and crushes down and harms somebody. And Robin, in fact, you and I worked on a GM roof crush case a few years ago. And so it's, yeah. And then we just finished a crane case, and we've got another crane case in the office now where cranes have failed and people have been hurt. So a variety of different types of cases.
And you sort of have to become an expert on those defects yourself, even though you say you're just a trial lawyer, and I would never say just a trial lawyer, but you have to learn a lot of engineering and science yourself about each defect.
Yeah, a lot of engineering and a lot of medicine. And a lot of times, reconstruction type work, physics, understanding speeds and velocities and changes in velocities and those sorts of things just over the years. And I was not a math or an engineering major in high school. In college, as you heard. And so I've had to learn on the job a lot of those areas of expertise.
Well, let's talk about the Melton case. When I introduced you, I left out the fact that you are also a published author. And the book that you wrote is called Cobalt Coverup, The Inside Story of a Deadly Conspiracy at the Largest Car Manufacturer in the World. And it involves the case of Brooke Melton, who was killed in a Chevy Cobalt back in, I think, 2010. And she died on the day of her birthday. I remember that. And tell us a little bit about that. The Meltons, you take us through it in your book, but just like a family looking for help and answers, and they walk into your office, Ken and Beth Melton walk into your office one day and say, we don't know what happened to our daughter.
Yeah, what was unusual about Ken and Beth Melton, them coming into my office, they were actually referred to me by the insurance adjuster in the case. And just to set the scene, Brooke had inexplicably lost control of her Cobalt, gone into the oncoming lane of travel, and impacted another car, which caused her death. And the people who were in the right lane, and of course, hadn't done anything wrong as well, they were injured. And so they were making a claim against Brooks Insurance because at that time, no one knew about the defect in the vehicle. The police officer had determined that Brooks was driving too fast for conditions and caused this crash. And so a lawyer for the two people in the other vehicle had approached the insurance company. And Ken was concerned about the estate and whether he and Beth could be held personally liable in addition to Brooks Insurance. And so they just had questions. But Ken also had questions about what had happened because of what had happened a few days before where the vehicle had been serviced. Brooke thought everything was fine. And the next thing you know, she's a young woman, sober, belted, a good driver. How could this have happened? And so Ken, as in part as a grieving father, but also in part as someone who really suspected something went wrong. And Ken and Beth came together, but Ken was the one who was very upfront about wanting to get answers to certain questions.
And that sort of initial meeting where we need answer questions, I take it that you really had no idea what had caused this wreck. I mean, you had no clue yet. You just felt compelled from the Meltons that usually.
Well, and it goes back to what I was talking about before. It was a case that was really, when you looked at the police report, it was cut and dried as far as her losing control. But there were so many factors that made it unusual. Like I said, she's losing control for no explained reason. She's belted. She's sober. There doesn't seem to be any reason for that to have happened. And so this is one where we told Ken and Beth that I was pretty candid with them. I said, the police officer has determined this was 100% Brooks' fault. There's nothing in the report that would indicate otherwise, but we've got some experience and we feel like, I think this is a case we should investigate. And most critically, in this case, we bought the vehicle because the vehicle ultimately ended up telling the whole story. And so we secured the vehicle and then just began our investigation.
So so it seems to me there are at least two kinds of products liability cases, probably more than that, sure. But, some involve crashworthiness where maybe what happened with the vehicle didn't cause the crash, like you're talking about with Brooke Melton here. There was a defect that caused her to go into the other lane. And there are others where the crash is maybe caused by something else, but there's a crashworthiness or safety factor involved in the vehicle. Could you talk a little bit about the difference in those two types of cases?
Yeah, and the difference exists in the Cobalt, Lester. So you're right. So when the switch would turn too easily and cause the car to shut off, that would cause a loss of control. So that's not a crashworthiness case. That's just a defect that causes the crash. And in this case, however, when the switch would go off, the airbags wouldn't work. So there were a number of Cobalt cases where the switch went off, and then someone was involved in a collision where the airbag not working caused their death. And that's the crashworthiness case. In other words, that's saying, hey, even though the switch turned off and someone lost control, if your airbag would have worked, you would have walked away from this crash. But it wasn't crashworthy. In other words, because your airbag didn't deploy, you suffered harm that you shouldn't have suffered if that safety device had worked. And that's the distinction really that existed in this, both claims essentially, or both theories of defect existed in the Cobalt.
So the defect in the Cobalt was this ignition switch that would unexpectedly go into what's called the accessory position. Is that right?
Yeah. So if you think about it, nowadays there's a lot of push button ignition switches, but still there are a lot of cars that you have a keychain, and you turn the switch, and when you turn it to on, an accessory is just when you're sitting listening to the radio, and an off is it's off. And so when people would be driving down the road, they could hit a pothole. And if their keychain dangled enough, it would turn the key from run to accessory or run to off. Or they could bump it with their knee if they were changing the radio. And the GM engineers knew about this before the first Cobalt was ever sold and didn't do anything about it. We ultimately discovered. So it was essentially just, it was a simple as we showed, it ultimately was shown a simple defect to fix. They just chose not to. And it was common. I mean, people driving down the road, there were hundreds of complaints where people were calling GM saying, my car's shutting off. What are you going to do about it? And because it was shutting off literally for tens of thousands of vehicles where people would be driving in an ordinary manner and the keychain would turn, cause when a keychain moving in some direction would cause the switch to turn.
And ultimately you discovered that, but you had to climb Mount Everest to be able to discover that. Tell us a little bit about hiring your experts and how your expert witnesses helped discover the ignition switch and ultimately the kind of grand cover-up done by GM on this switch.
Well, it's interesting because Ken, in one of our meetings, I can't remember, it was an early meeting, I can't remember which one, brought a recall notice in that he had received about the Cobalt, because his mail was being forwarded, Brooks' mail was being forwarded to him, and it was a power steering issue. And so it caused me to think, well, maybe there's some problem with the steering here. And so I called around because I had not had a powering steering case before. And y'all know Cale Connolly. Cale suggested Charlie Miller, who's a mechanic out of Mississippi, who ended up being the best expert I ever had. And he's just a wonderful man. And Charlie came out, and long story short, said that the vehicle download had been done. And if y'all know, it's a black box. And we had that information from the black box. It showed how fast Brooke was going 5 seconds before the crash and zero and at the moment of impact, and provided a lot of information about braking. But it also had this unusual information where it said at the moment of impact, the key was in the accessory position. And Charlie said, I really don't understand this. What the significant, he thought he knew what the significance was, but he'd never seen it before. And so that's and as I said earlier, that told the whole story, frankly. And that is the key was in the accessory position when the crash occurred. And so we had to then determine, why did this happen? And Charlie helped us with that immensely, and really found ultimately back in this car was developed in 2004, first sold. He found a technical service bulletin on a GM database, because he was a mechanic, so he can get on the GM mechanics database, technical service bulletin explaining this problem, and not recalling, not doing anything, but making this minor change to the key, which did address the problem, but they kept selling cars with the old keys. So if you can imagine, they identified a problem in late 2004. They said, we've got this fix for it. We just need to change a part in the key. And when people call in, we'll give them that fix. But all the new cars we're making, we're still going to keep making them with a bad key. The conduct was that egregious. Now, we didn't find that out till later, but Charlie discovered this technical service bulletin. And so General Motors, we served initial discovery. We filed a lawsuit, served a document request, and they basically gave us nothing. And but based on what Charlie had given us, and you all know this in your experience, we knew there was more there. We just said, there's no way that there's not more there to this story. And the lawyer for the defendant, a lawyer for GM kept telling us, you've got all we have. You have all we have. So we filed our motion to compel, and he called us up and said, well, we have a little bit more. But now you have all we have. And we said, no, we don't think we do. And so really what we focused on is, when they gave us a lot of information that was helpful, we were focused on, yes, but there have to be other crashes involving this. I mean, this is not an isolated event. And they kept telling us, this is the only crash out there like this. And without going too long, there were really two more critical points in discovery. We fought them. We were having a hearing on a motion to compel, and they finally produced a significant number of documents. And I asked Doreen Lundergan, the paralegal in our office, who's fantastic, I said, could you help review these documents in order to see what they say? And she came into my office and said, you won't believe what I found. And she found a 2004 internal report from the manager of the Cobalt, where they basically had evaluated fixing the problem with the key and had a lot of engineers investigating it, and ultimately turned down the proposal to fix it because it was not an acceptable business decision. In other words, it would cost too much money. And that really opened the floodgates in the case. And we ultimately went to Judge Tanksley, Catherine Tanksley in Cobb County here, who ordered them to produce some additional documents. And well, we can talk a little more about it, but that's sort of the brief overview of the chronology.
I saw that ultimately Judge Tanksley ordered production of eventually 4,123,346 pages of documents. That's almost unimaginable.
Well, and most of those came after the case, after the initial case was over, when the federal government got involved belatedly, unfortunately. And Congress was involved and Senate was involved, and GM all of a sudden realized we need to come clean, or we're already in a lot of hot water. And if we don't come clean, we're going to be even more hot water.
Gotcha.
So how did you know you weren't getting everything? I mean, sometimes, when you get a bunch of discovery from a defendant in a case, you can see where, there's email chains or something where there's not an answer. Other times, I guess I've sort of had a little sort of a country feeling that there wasn't, everything wasn't there, but not ever with anything this large and with the amount of documents that you and Robin are talking about here. So how did you know you weren't getting everything, and how did you go about in your motion to compel proving what is essentially something you don't have access to, that they've got this, and we know they've got this, and so they need to turn it over?
Right. Well, two points to that. One reason we knew we weren't getting everything was there were a couple of more technical service bulletins. So we have these technical service bulletins between 2004 and 2010 relating to this issue of unintended power off of these vehicles. And the question was, well, these technical service bulletins didn't come about in a vacuum. I mean, there had to have been an analysis done and a decision made in order to send out the bulletin. So we knew there was more to it than that. And then there were also, there were other documents that they produced, which indicated to us there were more documents. And we didn't know this, Lester, but we had a strong suspicion. So all we said to GM was, withdraw your objections to our requests and tell us you've produced everything, and there's nothing to fight about. And they refused. And so when we went to Judge Tanksley, we said, Your Honor, all we're asking, our requests were legitimate. Their objections are without merit. They refused to withdraw them. There's got to be a reason why. And then the GM lawyer was questioned. The transcript is fascinating with Judge Tanksley, the GM lawyer. And she said, well, do you have these documents? And his response was always, based on our database search, this is all we found. And she says, I'm not asking you, you can include anything on your database search and hide all sorts of documents. I just want to know, does General Motors have these documents? Or have there been other lawsuits? Based on our database search, she grilled him at the hearing, because what he was saying, it was so obvious. He had been told by GM, listen, these are the terms we put in our database search. If it doesn't come up with anything, we ain't got no documents. And she knew that was not the right way. That's not the way discovery is supposed to occur. It's kind of like if your client says, well, based on my search, my database search of my computer, there are no responsive documents. Well, the question is, well, what's on your computer? Not what did you search? And so that's how it came about. And Judge Tanksley saw through that and issued the order she entered.
Would you have been able to win the case without that?
We had enough evidence at that point to prove the defect and to prove that the defect was a cause. We had other experts involved, including Mark Hood, who just did, we can talk about Mark in a moment, but the short answer is yes, but we didn't have the strong punitive damages claim we ultimately had when we discovered all that evidence.
Let's talk about how you've finally discovered, you've discovered a defect in the ignition switch, but then ultimately you find out that GM knew about it and lied about it and covered it up by fixing it at some point, but using the same part number as the old switch so that if you looked at it, you wouldn't know.
Yeah, that's when
that was some incredible detective work.
Well, I'd like to take credit. I'll take credit for it to this extent. I hired the right expert. Charlie Miller. Charlie Miller referred me to Mark Hood, who was a professional engineer at Swain Engineering down in Florida. And I'd never worked with Mark before. But I flew down there, and before we flew down there, well, let me back up. We had decided that we were going to pull Brooke's switch out of her car, and Mark was going to test it to see how strong it was, how hard it was to move it from run to accessory to off, because it has to have a certain amount of force requirements to keep it from turning. And so Mark said, I'm going to buy a couple of switches and just evaluate them in order to see kind of how they work, and just wanted to get an understanding of the switch. And so he bought these switches and he put them in this test rig, and he found that they were much harder to turn. In other words, they had enough force to keep the switch in run, even if the key jostled the switch. And so he told me that, and we met and we had a meeting with GM and its engineers, and we showed GM, your new switches are stronger than your old switches, even though they're supposed to be the same switch. And Brooke's switch was way low. It was way inadequate, and we knew that. And so Mark, he didn't stop there. He said, there's got to be a reason for this. And so I flew home, and he calls me up, and I was out of town, and he said, and this is another, you're not going to believe it statement like Doreen's was. He's not going to believe what they did. And I said, what? And he said, they changed the switch. And he found, without getting into too much detail, he just found through taking apart the switch and then x-raying it and scanning it, that the pin in the switch was just more robust than the new switch, more robust than the old switch. So it wouldn't turn as easily. And Brooke, if she had had that switch, would never have, this never would have happened to her. And ultimately, we discovered that GM's changed this switch out in 2006 for the newer switches. The vehicles and the newer vehicles had the better switch. And here Brooke's driving in 2010. She'd taken her car in that weekend to be fixed. GM had switches available, and they didn't put it in there. And so 2 days later, Brooke has this tragic accident, which obviously not only was preventable, but was knowingly covered up. The defect was knowingly covered up. And that's when, the lawyers for GM, I waited and just talked a little bit about a tactical decision. Mark called me about that. And we had already scheduled the depositions of the deposition of GM's switch engineer, the guy who designed the switch. And I put that, but Mark's deposition was scheduled before that. I didn't want GM to know what we knew. And so we put Mark's deposition off, and we put the switch in front of the GM engineer, both the new switch and the old switch. And it was one of those aha moments where he couldn't explain it, and basically perjured himself repeatedly in the deposition as far as what he knew and when they knew it. And that's when GM realized we need to do something about this case.
That deposition.
I hope that's not too much detail, but that's sort of.
No, I was going to say, I bet that deposition for the GM lawyers was like they're sitting there and you're asking questions about this new pin in the switch and it's stronger. And they're like, oh my God, that's got to be one of those. He knows the gig up. He knows when you're in, certain kind of questions you're asking, they've got to know. But
yeah, well, they did know. And what's interesting is after the the federal government's investigation, they had to produce all of the communications between GM's lawyers, outside lawyers in this case, and in-house lawyers. And one of the first emails that went after the deposition was from the lawyer who was sitting in the deposition to one of the chief in-house counsel saying, essentially, we've got a major problem. And I can't remember what the quote was, but it was essentially, we're in trouble and we got to do something about it.
I bet they use different language.
Yeah.
I'm just guessing.
they did. We cleaned it up.
We have a family podcast here, so
yeah. So ultimately, that turned the case for the Meltons, and all of a sudden, I think GM wants to resolve the case with you. Is that right?
Yes, and Ken and Beth initially did not want to. They left it up to me. And GM had been trying to settle the case for about a year and a half. Before they produced the initial batch of documents, their lawyer called up and said, hey, this is not a good case for you. Your client's at fault, but we're willing to, do something to help the family. They're nice people. And Ken and Beth basically said, Lance, we'll be ready to settle when you tell us we should settle, or we'll be ready to, to discuss settlement when you, and so finally, we had what I believe gotten everything we could get out of them. And we had a problem in the case, not to get too into the weeds, but we had a problem that the dealership had screwed up that weekend. They had not done some things they should have done. And so there was a real issue of whether the dealership could be held responsible for what happened. And so Ken and Beth, we sat down and mediated with GM initially, and we're able to resolve the case with them and keep the case alive against the dealership. In the meantime, I kept trying to determine what I could do to bring this to the attention of the public. And this is where the story gets even more interesting, in my opinion, because historically, NHTSA, National Highway Traffic Safety Administration, has not been favorable when lawyers have provided them with information regarding defects. And in this case, I was really concerned that if I went to NHTSA, that GM would bamboozle them and that this defect would not be uncovered, essentially. So what I was trying to do is determine who, I'm not a class action lawyer, but determine who we could hire as class action counsel to file a class action. And in the meantime, GM realized they had a problem and issued the recall in February, early February of 2014.
Lance, most folks who run businesses, and we're, even lawyers, we run businesses, and from time to time you have a problem, and most, I think, small business owners at least say when you have a problem, you go try and fix it. You try to make it good. See what you could do to resolve it. But I think I'm correct in saying that recalls are a very small part of what large automakers want to do with regard to discovered defects. Is that correct?
Yeah. And what's tragic in this case is we were able to GM found out about this. It was undisputed because when we deposed this gentleman and showed that they had fixed the switches, GM knew about that in April of 2013. They had a duty under the federal law, and they knew about it much earlier than that. But just assuming that we showed them there's a defect and you need to deal with it.
This is after Brooks' dead.
This is after Brooks' death. Yeah, in the middle of our litigation. They delayed from April of 2013 to February of 2014, and there were a number of crashes in the interim where people died or were injured. And that's there's a lot of outrageous facts in this case. That's at the top, close to the top of the list for me, and that is, the litigation civil justice system worked. It uncovered this defect. I showed you in a deposition with your engineer, there's a defect that you have fixed in these newer cars. And you kick the can down the road for 8 months and people die or are injured. And then, in February, they sent out this innocuous recall notice, not explaining anything about what they knew or when they knew it. But hey, we got this issue. We'll change out the switches. No big deal. And it wasn't until I had to send a letter to the federal government called the timeliness query to say, wait, they sent you this little one-page letter about, let me tell you the rest of the story, what they knew and when they knew it. And that's when they realized we got trouble. And so they expanded the recall because I told them they've only recalled about, I can't remember what it was at the time, 400,000 or 500,000 cars, which is a lot, but it's not nearly what they needed to. And ultimately they had to recall over 30 million. And again, that was with the assistance of other people who are helping me navigate the NHTSA process and the federal government process. But it just shows time after time when they could do the right thing, even after they had done all these wrong things, they chose not to, and people continued to die and be severely injured in these crashes.
You ultimately did reach a settlement in the Melton case, and then something happened, and you decided, let's undo the settlement because this is not right. Tell us about that.
The reason is after the recalls were enacted, or the recalls were instigated, I was watching one of the hearings where it was either Mary Barra or one of the other GM witnesses, and I can't recall at the time, brought up the fact that they had produced a document in 2006 showing that they had changed the switch and they knew about the change. And all the way through the litigation, all we could show was you changed the switch, but they couldn't say, they basically said, we don't have any information as to why this happened or how this happened. And it was a couple of smoking gun documents that were produced that Judge Tanksley had ordered them to be produced. And I went back to Ken and Beth and said, Ken, they committed a fraud on us. They didn't produce documents they should have produced. We settled the case with the understanding that they didn't have those documents. And I said, I'm recommending that we offer to give the money back and refile the lawsuit and ask for other documents they haven't given us so we can prove to a jury that not only did they cause Brooks harm, but they committed fraud on Ken and Beth in the court in not producing the documents, which ultimately resulted in a settlement that they wouldn't have taken had they known all those facts. And so we refiled the lawsuit. GM hired all sorts of lawyers, very qualified, high-profile lawyers, but Judge Tanksley, fortunately, denied their motion to dismiss and said, you're going to trial. And then the case kind of unfortunately devolved from there because there was a federal case involving a number of lawyers who did not have the same interests that the Meltons had. And they sort of took over the litigation. I don't need to get into all the details about that. I talk about it in the book, but it was a very unfortunate experience because we were no longer allowed to pursue the case that we wanted to pursue because a federal judge was, and the lawyers in the federal case decided they wanted to take over the case, which was very unfortunate.
And then I think ultimately you settled again with GM. I'm going to just guess for a significantly higher number the second time.
Yeah, it was. Well, we went to Ken and Beth. One of the things we did in the second lawsuit is I said, I want to know what the lawyers were saying to each other. Who knew what when? Normally, as you know, you're not able to get at that. And we didn't get at any of that in the deposition. But some of that was in the Valukas report, which we haven't talked about, but the federal report that was GM had asked for. And so we wanted to get all of that deemed unprivileged, essentially. And before the motion to compel with Judge Tanksley, GM had to basically agree to that. And so we more or less had all the documents we thought we needed. We had the whole story. Ken and Beth had done all they could do as far as getting the truth out. And they had been through a long 5 years at that point. And so GM came to them and we were able to resolve the case.
I don't know how many times a lawyer has had one of their cases become the subject of a congressional investigation. I have never had that, fortunately, with any of my cases, but the Melton case did, and the GM ignition switch did become the subject of that. And you mentioned Mary Barra, who I guess was at the time the CEO of GM, and I think is currently the CEO. We're going to talk about another case in a minute. But I wanted to read a little piece from your book about the Senate hearing on the GM ignition switch, where Senator McCaskill was questioning Barra. And you said you thought that Senator McCaskill could read your mind. She asked the CEO, and quote, "Now here's a really important question. The document, which is completely relevant to any lawsuit that is filed against GM around these crashes, would have been included in any document request from any lawyer representing a family. This document was not given to Mr. Cooper. This document was withheld from the lawyer representing the family of Brooke Melton. How do you justify withholding a key piece of documentary evidence in a litigation concerning a part that was changed without a part number change, as it is spelled out in this document for anyone to read? How does that happen?" So you're watching this, I guess, from home. I'm not sure if you were in Washington at the time, but you're watching it, and what were your thoughts?
Well, that was what I was talking about earlier. When my thoughts were, these documents weren't produced, and Robin didn't know about those documents until the hearings, because we had obviously the government wasn't cooperating. They weren't interacting with us, Congress and NHTSA at that point. They were conducting their own investigations, and so I remember I was sitting with Sonia on the couch watching the hearings, and I believe it was Senator McCaskill, but there were a couple of Senator Boxer also had some questions or comments, and realizing, wait, they've committed fraud essentially, and not only against us, but against Judge Tanksley and the system. I mean, our system only works if the rules are followed. And fortunately, we had a judge here that was going to force them, or tried to force them, but they still didn't follow. And that was one of the primary reasons for the second lawsuit.
So we're talking about, at the time you settled the case to begin with, the first time, the part had been changed, the number had left the same, and I just want to make sure I've got this correct. It's the trial lawyer in me. You want to ask the question twice so the jury hears it. I want to make sure our listeners hear it. GM's explanation, if I understand it correct, is, oh, wow, gee, yeah, this is just a different, this is a different part, but we don't know, we don't know how this happened. Maybe it was the parts fairy that came in and designed this new part. Is that correct?
Well, it wasn't, and to your point, Lester, it wasn't the parts fairy. Delphi was their supplier. And Delphi was bankrupt. You remember all the bankruptcies back in the late 2000s.
Right.
So their position was, we don't know, but Delphi was our supplier. And, we're not going to tell you they did it, but maybe, maybe it was them, maybe it was somebody else. But it wasn't, we have no idea how this happened. And of course, that's, if you don't have the smoking gun, it's hard to refute. And particularly if you're trying to get punitive damages, they're going to come in and say, well, we don't know. And of course, that's what made the evidence so damning, was because it showed there was a GM document with GM engineers on it, which showed not only did they know, they authorized and approved it back in 2006, 4 years before Brooke died.
In cover-ups like this, and I ask this as, all of us have been involved in different sort of leadership positions within the profession. And, are clients or big corporations able to pull this off, or in your view, are there lawyers that are sort of have to be complicit in it to try to get away with something like this?
Well, in this case, the lawyers were, if not complicit, had knowledge and closed their eyes, because that was the whole point about, again, another point for refiling the lawsuit is, what did the lawyers know? And what we ultimately discovered, based on the normally privileged documents that were produced, they were advising their clients years before, their client GM, to settle these cases. There'd be a 50-mile-an-hour crash and the airbag wouldn't work and the teenage girl would die. And the lawyer would say, you really need to settle this case. At some point, the question is, well, what's the lawyer's responsibility, particularly the in-house lawyer, to say, wait, this is not just a one-off. This is a problem. We need to do something about it. And if we don't, what's going to happen is what happened in the Melton case. So, I think more often than not, what probably happens is lawyers just turn a blind eye. When they have the evidence and they're advocating for their clients, which is reasonable and appropriate and necessary, but there's this line that no doubt is crossed at times between advocate and, if not cover up, certainly turning away from it.
One thing I wanted to have you talk a little bit about was, you mentioned it earlier, the Valukas report. And as I understand it, it was Mr. Valukas was hired by GM basically to investigate the situation, and seemed like a bit of to whitewash it for GM, especially going forward. Can you talk to us a little bit about the Valukas report and its significance?
Sure. It was a whitewash. Mr. Valukas was hired. He'd worked for GM before. And he was hired to basically get to the bottom, get to the root of the problem. And so what he identified was what anybody could identify. He just happened to have the opportunity to interview engineers and other GM employees and have all the evidence at his disposal. But he basically said, hey, this is really, there's no nefarious intent here. It's just, it's just really negligent conduct on the part of this company. And, there was this rogue engineer that was involved with the change in the design, who was not a rogue engineer. People knew about it, but that's what he was hired to do. Because GM at the time, when you think about it, I was interviewed by Neil Cavuto, and his question was, when is GM going to go bankrupt? I mean, it was a whirlwind for a few months there because of and people knew what they had done at that point, and they were angry, and they were thinking GM's not, particularly this is not too far off the heels of the people bailing GM out, the government bailing GM out a few years earlier. And so GM was, so to quote, in a fight for its life at that point. So they got ahead of it, and Valukas came out, and so the press bought it. The press basically said, gosh, look at all this dirty laundry that GM is airing, and they're really trying to reform and do the right thing. And I could read between it and say, no, what he's trying to do is make sure, first of all, the executives are totally out of it. And so his point was, no one at the top knew anything about this, or even close to the top knew anything about this. It was all the minions, first of all. And it really wasn't intentional. It was just some bad conduct negligent conduct that, yeah, they need to fix. And they will, they're going to put reforms in place to fix it. And it worked, because the press, for the most part, talked about the scathing Valukas report and how GM put itself under the microscope. But it was all a press plan, frankly. And really, if you want to talk about the Buchanan case for a moment, that proves it was all a press plan.
Mm-hmm. Mm-hmm. Yeah. And the CEO in her congressional testimony kept referring to it like, oh, it's all fine now because we've had the Valukas report, and this will never happen again. Basically, she said, we've put measures into place that this will never happen again. But lo and behold, at least what it looks like to me from what I've read of the Buchanan case, it has happened again, regardless of the speak up, whatever they call that, speak up program at GM.
Speak up for safety. Yeah, so back in 2014, shortly after all this happens, Marie Buchanan's driving in Paulding County, Georgia, same county that Brooke Melton was driving in. She loses control of her Trailblazer inexplicably, rolls over, and is crushed by her roof in her vehicle, Trailblazer. And we filed a lawsuit thinking it was a switch case. Got discovery showing that there's a defective sensor in the steering wheel of the vehicle, which causes the safety device not to work, stability control not to work, and that's the reason why she lost control. And ironically, one of the lawyers working on the case for GM, an in-house lawyer, sent this case to the Speak Up for Safety program, the program Mary Barra instituted in 2014, basically saying this is an issue. This crash happened, and they undertook an investigation, and the investigation showed they had tens of thousands of sensor failures in these vehicles. It's hard to determine how many crashes because the black box doesn't talk about this, but they have them. They have tens of thousands of these, and they conduct a full-blown investigation. The sensing that if the sensor fails, a stability control safety device will not work on the vehicle, which they promote as an important safety device. And so they conduct an investigation after the Buchanan lawsuit's filed, and they decide not to do anything about it. So there are tens of thousands, if not hundreds of thousands, of GM SUVs on the road today, built in this time frame, that have these defective sensors. And we simply sent a request to the local judge. Sent a request to GM. We wanted to depose Ms. Barra about this because she's the one that instituted this program. She promised that there's not going to be another fatality under these circumstances. And then she submitted an affidavit saying, I don't want to be deposed because I know nothing about this. And our point at the hearing was that should be Exhibit A to why she should be deposed. Because she said this was never going to happen again. And the trial judge saw it for what it is, and that is, well, sure, she's a witness. She created the program. They conducted an investigation under the program. They didn't do anything about it. And of course, he granted our motion to depose Ms. Barra and went to the Court of Appeals. They affirmed the decision recently. And it's ironic, if you look at they've applied for what you all know is certiorari, and that is just they're asking the Supreme Court to look at this. And it's amazing the number of business interests. I think we filed a brief on our behalf, and I think there are 10 or 12 business interests from the U.S. Chamber of Commerce to the Georgia Chamber of Commerce and every group in between that are fighting the fact that Mary Barra ought to be deposed because a young lady died in Paulding County, Georgia.
No one wants their CEO deposed, but particularly Mary Barra, I would guess. I'm just thinking, if I were in her shoes, I wouldn't want to sit across the table from Lance Cooper. That's just me. Maybe she's different, but I know she's not going to enjoy that moment. And I pulled the opinion. That opinion came from the Georgia Court of Appeals on May 6, 2021. Fairly recent opinion, but they quote the trial judge who basically quotes Miss Barra's own congressional testimony, kind of put it right back in her face. And it says the court pointed to Barra's public statements during recent litigation, which I'm assuming is Melton, regarding different alleged vehicle defect and other statements Barra made concerning GM's safety and efforts to investigate and eliminate safety issues, which is the whole point. She said it would never happen. We've got these programs in place. And lo and behold, now there's this defect that apparently is in about 770,000 GM vehicles.
Yes.
So is that deposition scheduled yet?
No, the Supreme Court has to rule on the petition, and then we're hopeful. Obviously they're going to make their decision, but we're hopeful that'll happen in the near future.
Yeah.
Which, by the way, it bears pointing out that the U.S. Supreme Court only hears about 80 cases, I think, in a year, and very few cases that involve an attempt to stop a deposition go above the trial court level. I mean, you may have some scuffling in the trial court about that, but the idea that it's already up, asking the Supreme Court to take it with friend of the court, so-called amicus curiae briefs by the Chamber of Commerce and everybody else, shows that it's getting a little bit different resistance than what you normally get in an automobile accident case. Fair to say, Lance?
That's fair to say.
Lance, at one point when you're wrapping up your book, your last chapter is called A Happy Ending. And you say this: the civil justice system is accountable in ways that government oversight never will. My question is, do you think the civil justice system righted a wrong here, uncovered the defect? You used the civil justice system. Did it work for the Meltons?
Well, it didn't right or wrong because Brooke's gone. It did the best it could to right or wrong. It did the best it could, and it worked as it should. It worked. I've made this point before. This is a way that it didn't work. In 2017, 2 teenage girls in Wisconsin died as a result of this defect. 2007, excuse me. 3 years before Brooks crashed, 2 teenage girls in Wisconsin died as a result of the defect with these airbags. The airbags didn't deploy in a crash. And those families went to good lawyers in Wisconsin, and they were told, we can't pursue it because there are wrongful death caps in Wisconsin. And your teenage children, it wouldn't make any sense financially to pursue the case because we would spend more than we could recover for the wrongful death of your daughters. That's where the civil justice system doesn't work, is when laws are put into place to prevent people from going to court and holding wrongdoers accountable. So I've made that point often, and that is we need to be vigilant here in Georgia and everywhere, but particularly here in Georgia as Georgia trial lawyers, to preserve access to justice, not only for individuals, but for businesses, for everyone, so that everybody has an opportunity to go to court and right a wrong.
Lance, you often talk about your faith. I know you about it quite a bit, and you are very upfront and open about it. And you mentioned it numerous times in the Cobalt Coverup book. How does your faith play a role in how you practice law?
Well, it's really integral, and I think it's because of the kind of law we practice, and that is we have cases where we help people when they're in their worst circumstances. You know, when they're either being oppressed somehow or they've been harmed in a wrong manner, and so that in and of itself, the type of law that we practice, to me, I've been called to that. I think in large part because that's where God's put my heart. It's a business, and there's no doubt about it. We have to keep the doors open here, but it's also a calling, and I think it is for all of us, whether we have a faith or not. But it draws me in because of my faith. And the example is this: I have no doubt that God providentially brought Ken and Beth Melton into my office that day. You know, He did, and that was a gift to me. What happened to Brooke was we'd like to turn the clock back, but at that point, that was a gift because it sent me on this journey, but a journey with them, and then meeting all of these other people I met along the way. And I've had my 15 minutes of fame, as Andy Warhol said. I mean, I'm never going to have probably another Melton case in my life, but I'm grateful for it. I'm grateful to God, the relationships I built, and I was really grateful to get to know Ken and Beth and share, because we share a common faith. And so I realized, and in every case, I don't, when a client comes in the door, I don't wear, my Lord and Savior on my sleeve, but I try to act in a way that honors Him. And we all do here in the office. And as we know, there are so many biblical admonitions about what we do in helping the poor and the oppressed and the orphans and widows. And I know the kind of practice y'all have, we're blessed to do that every day, even though it comes out of tragedy. As it says in Ecclesiastes, I can't remember what verse, but who can make straight what God has made crooked? In other words, this life is very crooked. But at the same time, we're called to help make it straight in some way. I hope that answers your question.
I think that's a very, very well
said.
It's
a beautiful answer. Yes.
Yeah. And I totally agree about the calling. If you look at some common law countries like Britain, they don't talk about being admitted to the bar like you have a ticket to come in, but you're called to the bar. Yeah. And I like that expression much more than admitted.
Yeah.
Well, Lance, our last question that we ask every guest, and I ask you to be thinking about it, is how do you define justice?
But I'm going to talk about it in the context of the law. And really, there's two separate concepts of justice that I would like to define. The first is restorative justice. And that is, I would define it as making things right for someone who is harmed by another. And what we do, our job is to do what we can to make things right for someone who's harmed by another. And that's the restorative, that's the compensatory aspect of justice. And as you know, as lawyers, that's really all we can do oftentimes. But then there's also retributive justice, and this deals more in criminal cases, but it also is in like the GM case, the punitive damages case. And I think it's the reasonable and appropriate punishment of wrongdoing. In other words, retributive justice in a case such as Melton, there should have been reasonable and appropriate punishment of the wrongdoing. The question is, was there reasonable, appropriate punishment? I don't believe so, but there should have been, given the magnitude of the harm.
I think I was going to say that GM, I think, ultimately paid $2.5 billion in fines and settlements for the ignition switch defect. And there was a class action settlement of $600 million for 124 deaths and various other injuries. And that's still not enough.
It's ongoing. They're still paying. There are still existing claims out there involving these vehicles. But the reality is unlike individuals, who, if you or I are DUI and we harm somebody, we're likely going to jail for a long time. These large corporations, and I'm as I say in my book, I'm as big a promoter of capitalism as anybody in this. I mean, I believe in the free market system, but the free market system also has to, it's critical it has a robust civil justice system. And you know, they got away with it to a large extent, because here they are almost, you know, what are we, 8 years later, 7 years later, and this is in the rearview mirror for them for the most part. Their stock is up. I believe Mary Barr is doing fine. The executives are all, they've either still there or they've taken their golden parachute. And Ken and Beth Melton are without their daughter. And so it's we did what we could, but as we also know from the scripture, you know, we're only going to achieve perfection when we get to heaven. You know, here we deal with the messiness of life the best way we can, and not to be too philosophical, but thankfully, you know, we're all able to do it in a way that we can make a difference.
Well, thank you, Lance. I think that's all we have for you today. It's been a fascinating conversation. At the point that you learned about the ignition switch and realized what they had done and covered it up, I got cold chills just thinking about that moment. But thank you for being a champion of justice, and for the civil justice system. A lot of people say, you know, our American civil justice system is the worst one in the world. Or what do they say?
Except for all others.
It's the worst one in the world. It's better than anyone else, any other one. So
You're right. You're right.
Your time. Yeah, we appreciate your time,
Thank you,
Lance. And thanks for being a guest, and we'll be following you.
All right. Thank you all. Have a good afternoon.
You too.
All right, bye.
Thank you. Lester, do you have any interesting news we can share with our listeners that has happened in the last couple of weeks?
I absolutely do. I'm going to tell our listeners about a story that came out on July 19th of this year. It's on CBS News, but there's also other articles about it in the Wall Street Journal and New York Times, other places. But jury orders Walmart to pay $125 million after it fired worker with Down syndrome. And Walmart lost this federal lawsuit in Wisconsin when a jury sided with its sales associate who had Down syndrome and fired her because of that disability. The jury found Marlo Spaeth had worked for Walmart for about 16 years before she was fired from the store in 2015 due to excessive absenteeism. According to the lawsuit, which was brought by the Equal Employment Opportunity Commission, which, as you know, Robin, that rarely happens. Most discrimination cases are not taken up by them. Spaeth's schedule changed after Walmart implemented a new computerized system in 2014, which created significant difficulty for her. And the thing that I want to point out for our listeners is this: the jury in federal court in Green Bay awarded Spaeth more than $125 million in punitive damages. The jury also awarded Spaeth $150,000 in compensatory damages. The substantial jury verdict sends a strong message to employers that disability discrimination is unacceptable in our nation's workplaces, EEOC Chair Charlotte Burroughs said in a statement. But they've buried the lead here, because it really doesn't send a strong message, because in the very next paragraph, the story says Walmart is likely to pay much less than the substantial verdict the jury awarded. A company spokesman told Associated Press the damages will be reduced to the maximum allowed, and this is because of caps on this type of litigation, just like our guest today, Lance Cooper, was talking about how they do injustice in other forms of litigation. And so the verdict is likely to be reduced to $300,000, from $125 million to $300,000. Now, I want to point out that, because we probably have a lot of listeners that say, well, I think that was a little excessive. You know, I wouldn't have given that if I'd been on the jury. And of course, the judge in this case, as we all know, because the federal rules of civil procedure, has the right to look at a remediature, which is a reduction of the verdict or whatnot. But what has made this a maximum, reduced to the maximum allowed, is $300,000. So what the federal government has done, and what state governments try to do routinely, in a lot of other states, we've been successful in avoiding those largely here in Georgia, is to put a one-size-fits-all cap in to say that regardless of what the circumstances, regardless of how egregious it is, regardless of what the jurors who have given up a huge portion of their lives and livelihood in some instances to sit and hear the facts, we're going to say that it's never going to be worth more than some amount that basically legislators, either state or federal, who've sort of been wined and dined by business interests, deem it to be worth. So that's mine for today.
Very good. Mine is actually involves a criminal case, but we've talked about it before because we had Joshua Sharp as a guest on our podcast, journalist with the AJC, and he's involved in this case. And I'm talking about the Dennis Perry case, where Dennis Perry was wrongfully convicted of 2 murders of the Swains. The murders were in 1985, and he was convicted of them. It was a cold case, and he was convicted of them in 2003, has served 20 years. And Joshua Sharp got involved looking at the case at the 20-year mark of Mr. Perry's incarceration, and helped find the fact that the DNA of a piece of hair in a pair of glasses left at the scene by the culprit did not match Mr. Perry. And so the Georgia Innocence Project got involved and started working to exonerate Mr. Perry, and they got King and Spalding, a very large law firm here in Atlanta, to help them. King and Spalding donated over 1,000 hours of their time to do this. They were successful months ago getting a new trial ordered for Mr. Perry. And then on Monday of this week, the new DA down there basically said, we are not going to retry Mr. Perry, and he is exonerated, and the judge exonerated him, said, you're free to go. So hats off to the hard work by the Georgia Innocence Project. And I'll give a shout out to my daughter, Alex Clark, who's happens to be interning there this summer before her 3rd year of law school. And she got to go to Brunswick and celebrate with Mr. Perry and Mr. Perry's family. And it was a pretty remarkable day.
And I would say too that story, that's the one where who they suspect is the true culprit said he had an alibi, so the police called the place he was working, and the culprit himself answered the phone and said he was someone else, but oh yeah, he was here that night, didn't commit it. And I thought that was one of our best podcasts that we had. And so folks that are listening to this, particularly with this news, if you haven't listened to the one with Josh Sharp, I hope you'll go back and listen to it, or listen to it again if you have before, because it is absolutely a fascinating story.
And you can find Joshua Sharp's, I don't know if it's a podcast or I guess you might call it a podcast, but it's on the AJC.com, called An Imperfect Alibi. And it exposes that and the pretty crappy work by the police officers down there, the detectives investigating. And the sad thing is Mr. Perry now is exonerated and never has to face this again, but he was wrongfully convicted. He lost 20 years of his life. And the Swain family now loses the fact that somebody who actually killed their loved ones is probably not going to be tried for it or serve time for it. So sad situation, but it just shows that our criminal justice system has some flaws. It obviously has flaws, and there are obviously people incarcerated who are not guilty of the crime they have been convicted of. But good ending for Mr. Perry and for the Georgia Innocence Project. And that's all I got, Lester.
That's all I've got as well, Robin.
Okay.
Great episode today with Lance.
Great show. Could listen to Lance all day. And until the next time, we'll see you in court.
Thank you for listening to See You in Court. brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Fraser Clark and Lester Tate, until our next episode, we'll see you in court.